To the session in front of the doctrine of double jeopardy. And one person, only one viewer is watching this video. But one point of the doctrine of double jeopardy, we would like to discuss in terms of the doctrine of double jeopardy in the human civilization. So first of all, we have to discuss in terms of the introduction and then what exactly the origin, the probing approach in terms of that very doctrine. For example, that the landmark decision in the war and the origin and which country actually apply this doctrine. This is the subject matter of our discussion. So let's start to discuss in terms of this situation. History is in front of me like this. The name of, you hear the name of Bishop. So this is the bishop, who lived in Medina. But there is a dispute between the two persons, bishop and Yehudi. So they actually had gone to Bishnobi, and the trial is in progressed. And what exactly the thematic mediation, the trial has been finished at the trial. Again, he has superseded the trialing approach from the side of Bishnobi. Then the person who was going to Hazrat Umar radiallahu anhu. And then the trial is in that very concept, taking Ani Ashoj and cutting the head of that very person named bishop. This is the systematic way, and that's why this is the process. Quranic declaration that 60 to 68, this is the Surah Nisa revealed in this respect, whether this is true or not. This is the systematic way. This is the first human civilization in terms of doctrine of double jeopardy. And not only that, in America, this is well known to you, Jack McCall in 1860, maybe 76. Jack McCall, who shot a person by a pistol. And this is the murder case named the Welch Bill. So this is the first landmark decision in terms of doctrine of double jeopardy in 1876. But this is the phrase in terms of the prelude. This is territory. In this territory, the American law is not applicable. So this is the issue in this very judgment. So no problem, the notion of ought prefers convict and double jeopardy is incorporated in what exactly the Article 35, Subarticle 2 in our Constitution, that the REPT Constitution. And not only that, CRPC prescribes that 03. This is the section which deals in this regard. That's the doctrine of double jeopardy. So it is a matter of happiness that there is a movie in 1990, maybe 1990, an American thriller movie. This is a double jeopardy movie. It's in terms of doctrine of double jeopardy. This movie should be prescribed from the side of law doctor to you to understand or comprehend that's the doctrine. But what is actually the doctrine? The notion of authorized convict or double jeopardy is incorporated in article maybe in several countries in the human history. For example, this is the Justinian Digest, and it's a carbon of prescribes that no man shall be punished twice. This is a Justinian Digest. Not only that, in Romans and the Greeks, and not only that, of course, Magna Carta does not prescribe, does not hold this provision, unfortunately. And not only that, this is the Article 50 of the UCPR, and that's Article 4, Subarticle 1 in UCHR, and Article 14, Subarticle 7 ICCPR discusses in this regard. And not only that, our CRPC, that the Code of Criminal Procedure 1898 prescribes 403. This is the section which deals in this regard. And not only that, CPC Leven article, what exactly section Leven discuss in this regard, and then what exactly Constitution, maybe Article 35, Subarticle 2 deals in this regard. And not only that, the SR Act 29th section, and then Special Powers Act 1974 section 31 deals in this regard. And not only that, the Arms Act 31 deals that very aspect, and not only Criminal Law Amendment Acts section 8 prescribed that, and not only that, General Clauses Act section 26 prescribes in this regard. And not only that, in what exactly, this is the Indian Constitution, Article 20, Subarticle 2 prescribe in this regard, that the doctrine of double jeopardy. And not only that, the section of the CRPC 300, 300 prescribe in this regard. And UK, this is the UK prescribe that's in this regard, and USA, what exactly the Fifth Amendment prescribe in this regard. And not only that, the Germany Constitution Article 103 Sub-Article 2 prescribe in this regard. And not only that, what exactly the Japan prescribed Article 33, 36, 39 maybe, 39 prescribed in this regard, that the doctrine of double jeopardy. So what exactly that several judgments and the landmark decision will prescribe in this notion that the authorized convict and double jeopardy is incorporated in Article 20, Subarticle 2 of the Indian Constitution, which says that the person cannot be punished for the same offense twice. Nemative vis facere si constat crucicut in pro unit idem cause in it. What exactly the thematic approach that pronunciation made? I don't know. So this is the systematic way. In English common law, maxim that expresses doctrine against double jeopardy, which means no man shall be punished twice if this appears to the code, and that it is not one and the same cause. Additionally, it adheres to the audio alterum quorum rule, which states no one may be received more than one punishment for the same offense. So this is the doctrine of double jeopardy. Double jeopardy basically means that if a person has been prosecuted, convicted once, cannot be punished twice for the same criminal offense. If a person is charged with the same offense and coached once again, he or she may assert the legal defense of double jeopardy. Origin. What exactly the origin? This origin, this idea which is referred in the code and seems to be part of the English common law in addition to every other schools of jurisprudence, has no particular genesis, leading to the conclusion that it has always been the Greeks and Romans out of this notion of double jeopardy. Now, we would like to discuss in terms of several landmark decisions in this regard. That the first landmark decision in the world is Jack McCall. What except here is the murdering system by shooting by a pistol. Wild Bill Hickok is the human civilization. And not only that, this is the murder. What exact the Deadwood city, in the city of Deadwood. But unfortunately, the law which is not applicable in that very city. So this is the first human system, and maybe 1876. This is the first landmark decision in this regard. So now I would like to discuss in terms of the several proving approaches in terms of the judgment with prescribes in terms of that. The first case is Indian case Maqbul Hussain versus State of Bombay in 1953. In this case, so what exactly the fact of that very case? The petitioner was an Indian citizen and who traveled from Jeddah to Bombay's Santa Cruz airport. He did not inform that he had tracked what exactly the 1250 gram of gold with him. And when landed, but when he was searched, he was discovered in violation of Indian government's notification. According to Sikh Customs Act 1878, Article 167, Clause 8, the gold was seized by the customs authorities. The owner of gold, however, was given the chance to pay, and what exactly 112 000 rupee fine, and which needed to be filed within 4 months of owner's debts. A copy of the order is given to the appellant, but no one is tapped forward to claim this gold. The same was raised in the relation to Ortrify's convict and double jeopardy. So the Supreme Court of India, well, that's a bank of the Constitution Criminal Appeal, considered the clear issue raised. What exactly the issue in this very case in terms of doctrine of double jeopardy? Whether the Sikh Customs Act 1878 and the order of court and the judicial tribunal can be used to support a plea of double jeopardy? What exactly the heading? And this is the decision in that very case in terms of the doctrine of double jeopardy. That should be focused by us. And the prosecution under the Foreign Resolution Act 1947 and was affected because the previous detention under the Sikh Customs Act 1878 did not constitute a judgment of whatever the court and judicial tribunal to support the argument of the double jeopardy. So what is the thematic approach in this very leading case in terms of the doctrine of double jeopardy? That should be focused by you of all towards the Ladakh chair. And not only another landmark decision in this regard, the Kalavati versus State of Himachal Pradesh 1953, maybe, I don't know, this is the hearing. Yeah, is not actually is not found in the head of mine. Sometimes I have forgotten that. In fact, what exactly the Kalavati versus State of Himachal Pradesh 1953? This is the landmark decision in this case. What exactly the facts of that very case? To save her from the cruelty, the accused plaintiff killed her spouse, defendant. The truth is that after the mistreated by her husband, she was striving to defend herself for cruelty. In this case, the correct murdered her husband in relation for harassing her. So this is totally adjusted to the point of view like this, the double jeopardy movie. This is the American thriller where we found that her husband was killed by her wife. This is the thriller, American thriller. This is the movie in tracking this approach, double jeopardy. This is adjusted to the Kalavati versus State of Himachal Pradesh 1953. So to save her from the cruelty, the accused plaintiff killed her husband. Defendant truth is that were being mistreated by her husband. She was trying to defend herself from the cruelty. In this case, the accused murdered her husband in relation to the harassing her. Due to the lack of evidence, he was declared innocent. Yet the stand ultimately appealed against her to the High Court. What exactly the issue in this case? Whether right to appeal under Article 20, Sub-Article 2 of the Constitution violates the case. This, of course, this is the Indian case of the landmark decision in terms of the doctrine of double jeopardy. The Supreme Court determined that because there was no sentence in the earlier chair, the appeal is continuance of a fair trial rather than it's neutral for the same offense, and thus it is not covered. What exactly not covered by the Article 20 and Sub-Article 2 as a result appeal against the conviction for murder would not contravene Article 20 and Sub-Article 2 of the Constitution. So another landmark decision in terms of that case is the Thomas Dana versus State of Punjab 1959. Again, please, I have forgotten that year, maybe 1959. So fact of the case is that collector of the Central Excise and Land Customs issued always confiscated seized goods and imposing heavy personal penalties on the board of petitioner and the two were detained with the foolish and attempting to smuggle a significant amount of Indian and foreign currency as well as other illegally imported goods out of India. The petitioner were found guilty and sentenced by the additional district magistrate. This resulted in an appeal to the Supreme Court. what exact that decision of the held? This in tracking this held, the Supreme Court decided that in order to request protection under Article 20 and Sub-Article 2, following requirements must meet the demand of that there was a previous prosecution, and as a result of this, the accused was punished, and that the punishment was for the same offense. And not only that, another Bajinath and versus State of Bhopal decision in Indian. In this case, the defendant was a government employee who had been charged with a crime under the Indian Criminal Code and sentenced. The prosecution was overturned in High Court appeal due to a lack of sanction. The accused was then once more prosecuted with a legal penalty. The court ruled, please write down just what I actually did, but to just the situation in this way, if you are actually hearing the systematic way, you you will be gradually adroit in speaking English. So no matter how I swear, that's whether this is very much difficult in nature. Just write an hearing system in which you systematic organ and the CPU that should be that should be helpful for you to understand that. So 0.5 because the first prosecution was declared to be invalid. Okay, so international perspective that the doctrine is being practiced in the international or the international arena. This the England. What exactly the thematic approach in terms of this is the what is the Macpherson report met recommendation of the murder of Stephen Lawrence, the first human civilization. In England, we can say that the Macpherson report made recommendation after the murder of Stephen Lawrence, including the repeal of the double jeopardy law. And the right to required murder suspect the case where the fresh and valid new evidence is later discovered. The commission eventually agreed with the judgment in its 2020, 2001 maybe, 2021. And report double jeopardy and prosecution appeals the suspect may be toward against the new circumstance if new compelling, reliable and significant evidence is discovered that was not previous, now it becomes not afterwards. Now the United States little Jack McCall, the Bill Hickok murder case in 1876, and not only that, several Abdul Qadir Mullah versus Bangladesh Sarkar in the 2013. This is the landmark decision in terms of this, the doctrine of double jeopardy. But what is the international double jeopardy that should be focused by us later? But today's session on point of Saiful Islam Sheikh Bangladesh Sarkar in the 50th year, what exactly the three? I think, this is the landmark decision and Mahmudur Rahman Bano. What exactly the versus Bangladesh and others? This is the 9 scope Supreme Court online bulletins 2017 SCD and at page 119. So in this regard, Mahmudur Rahman versus Bangladesh and others case discussed in this regard. No, and the O.P. Dalia versus of India 2003 convicted person, but there is a trialing process is not be applicable in this regard. So England prescribed that's a Macpherson report in this regard, and the United States Fifth Amendment of the United States Constitution established the principle double jeopardy. That's a Fifth Amendment case, but exactly in terms of that very systematic way. And England prescribed the rebirth and United States the Fifth Amendment, and Germany, what exactly the German Constitution Article 103 Sub-Article 3, which prohibits punishment for the same offense committed more than once under general law, refers to the idea of double jeopardy. So Germany prescribed, and Germany is practicing this doctrine. That's the doctrine of double jeopardy. And Japan, the concept of double jeopardy is covered in Article 33. Oh my God. 39? I forgot that. I have forgot that. Germany, what exactly the concept of double jeopardy is covered in Article 39 of the Japanese Constitution. Of course, this is Japanese, that is not Germany. So, 39 prescribes and 39 holds that very doctrine. It writes in the no one can be subject to the double jeopardy, and that no one can be held criminally responsible for act that was illegal, and when it was committed, for which he was found not guilty. In conclusion, every accused person has the right to at least one appeal following a conviction. It is referred to as an acquittal, and no further conviction is permitted if the force and is deemed unlawful and appeal owing to lack of evidence. And Article 20, Sub-Article 2, Indian Constitution prescribe in this regard. And not only that, several times I have focused CRPC, this is the 403 prescribed in this regard in our criminal procedure, code of criminal procedure, and the CPC prescribes 11 section 11 prescribed in this regard. And not only that, the article 35 subarticle 2 prescribed in this regard in the doctrine of double jeopardy. And Thomas Banner, not only that, the several judgment in this regard, and Ghiyasuddin Al-Mamun versus Stat, and the 65 dealer HCD, and 375, this is the page number. In this case, it is quite clear to us there is a systematic way in terms of when there is a what exactly that the acquitted or trifois convict and not trifois acquit. So this is the systematic way through which a person will not be tried again for the same offense. But unfortunately, several human civilization history prescribe that sometimes this is erroneously decided in the code of law, and that's why. So this is the first of all, and I would like to focus in terms of the synopsis. So what exactly the preface or the prelude in terms of that systematic way in tracking the double of jeopardy and the human civilization origin of that bit talking like this, the origin or the history like this, what exactly the history in several mapping system in the world, this US and UK, and not only that, Germany, Japan, India, and not only the Canada, Mexico, who have written constitution, they actually what exactly practicing, they are practicing this drafting. And not only that, in tracking this systematic way, a movie named what exactly the double jeopardy movie, that the film which is made by the American thriller movie, so that should be what gets watched by you. And not only that, so this is the landmark decision in the country, for example in our country like this, the Abdul Qadir Mullah versus government of Bangladesh, what exactly landmark decision. And not only that, Mahmudur Rahman versus Bangladesh and others, this is the 9th Scope Supreme Court online bulletin 2017, this is the HTD, and 119, this is the page number prescribed in this regard. And not only that, Saiful Islam Sheikh versus government of Bangladesh and the 50 DLR. What exactly the page number? 318, this is the page number which fresh cut in terms of that very doctrine. So the first one is this, the prelude of the preface, and then what exactly the origin of the history of that very doctrine, and the practicing in the whole world like this, this several laws prescribed in this regard. And not only that, the landmark decision in this regard, and then the concluding remarks. And what is your thematic approach in tackling this jurisprudential knowledge or the view or the philosophical, whether this is the sociological aspect, whether this is the positivist theory, whether it's the liberal approach, not only that, the economic condition, what not only the realist theory, that should be mixed and discussed in tackling this. That should be very much fruitful for you. And today's Namo. Bye-bye.